Alright, so the Pistorius verdict has come out from South Africa. It's been on the news quite a lot recently, and I wanted to give my thoughts on the matter. So just to give a bit of background, my thoughts and expertise lie in British law rather than South African law. And even though South African law is somewhat based on common law, the same stuff that we have in the UK, it's also got influences from French, Dutch and African customary law. So I'm not an expert in the ins and outs of South African law, but anyway, I thought it would be quite interesting to have a look at the case from a common law point of view. So the verdict, if you haven't seen it already, was that he was found guilty of culpable homicide. That is our British version of manslaughter, basically. And what I want to spend a little bit of time on is giving my thoughts on why or why not it should have been murder. So, to start off, one of the things that's been quoted quite a lot is the judge's statement that the prosecution failed to prove beyond reasonable doubt the defendant's culpability for murder. And I have to agree with that in the UK, because the burden of proof always lies with the prosecution. This has been established in common law in Wilmington and also in the European Convention on Human Rights, Article 6, and is essentially that phrase, innocent until proven guilty. That is a fundamental cornerstone of our criminal justice system. And I think a lot of people have been quite maybe disappointed with the way the trial was carried out, or in the way the evidence was gathered. I've certainly heard some opinions where they find that they thought the defendant was being overly shady or uncooperative, or you couldn't really tell if he was being honest or not. But then there's a right of non-self-incrimination in the common law, which is encapsulated in the Privy Council under Jayasena VR, and essentially, even though the defendant may not be fully cooperating, say without going into contempt of court, then they're not required to sort of collaborate fully in their own conviction. So providing evidence in the way that Pistorius did, or the defendant did, there's nothing legally wrong with that. People might be upset with the way that it was handled, and that they obviously want the truth to come out or something like that, or have those sorts of ideas, but there's nothing wrong per se with the evidence that the defendant was giving in this case. Okay, so let's move on to the murder stuff. I think the summation is that the defendant did not intend to kill Reva Steinkamp, or whatever the name of his girlfriend was. So it begs to ask the question, he did discharge 4 bullets into a door. Did he intend to kill someone? I think it was said that there was the threat of a home intruder. Well, we have something called the doctrine of transferred malice, which means that if you possess the required intent or mens rea to commit an offence, in this case we're looking at murder, so the intent to kill, if you intend, say, to kill one person, but by accident or whatever you kill a second, the doctrine of transferred malice allows the intent to kill the first person to be transferred to the second, so you have sufficient intent to kill the third party. So if it was found that the defendant intended, by shooting his bullets through the door, to kill the home intruder, could it also be said that when it turned out that he killed Reva, that his intent to kill had been transferred, thus making him culpable for murder? And that's one argument that you could put forward there. The second argument that might be raised is that he never intended to kill anyone, and this is sort of an important thing. So if the idea of the home intruder is there, when he fires through the door, he's not intending to kill the person behind the door, but to ward them away, or to, I don't know, injure them or something. Now this point here is that under common law, grievous bodily harm, or the intent to cause grievous bodily harm, is sufficient intent to make someone culpable for murder rather than manslaughter. Just a distinction: manslaughter is where you have done the act of killing someone, but you don't possess the required intent or mens rea to be guilty for murder. So that's what he's got. He's got manslaughter at the moment. So could it be murder? Well, just to give a bit of history behind grievous bodily harm and intent, there's a case, Hyam, which found that foresight of death or grievous bodily harm was sufficient intent for culpability of murder. So if the defendant had an appreciation that his actions could lead to death or grievous bodily harm, then that would make him guilty. Now, under that case, it would clearly seem that if you discharge your weapon, you must see there is some foresight for either death, grievous bodily harm, so that would make the defendant guilty in this case. However, Hyam's position was reversed by Maloney, where it says that only a specific intent to kill or cause grievous bodily harm was sufficient for murder. So just an appreciation that your actions will have consequences is no longer sufficient. You have to have a specific intent to cause or to occasion killing or grievous bodily harm. So then it comes into the sort of the debatable points. When you discharge your weapon through a door 4 times, is that showing an intent to kill or to cause grievous bodily harm? We can essentially write off an intent to killing because grievous bodily harm would be good enough to make the defendant culpable for murder. So I suppose this is a point for the jury in the UK or the judge in South Africa to find that, you know, when you discharge a weapon through an entryway, is that showing an intent to cause grievous bodily harm? I mean, as ordinary people, I'm not a firearms expert, but as ordinary people, when you discharge a weapon, it's probably going to hurt someone or do some damage, which, you know, and the kind of damage that you're doing is well within the remit of grievous bodily harm, and obviously there is the potential to kill, as we've seen here. So for me, discharging the weapon through the doorway does show an intent to cause grievous bodily harm, if not to Reva, then to someone, a home intruder, but through the doctrine of transferred malice, you know, that intent seems to be there. So I would have found in the UK under common law and that there is sufficient intent for murder. But anyway, that's my opinion. That's the, you know, and the case has already been decided, so this is all just moot points for debate. But then I suppose it's also important to talk about some of the defences. And with the idea of this home intruder, I thought I'd look into a little bit about provocation and also self-defence. So, provocation. Under Section 3 of the Homicide Act 1957, regarding provocation, even if the defendant is mistakenly thought to... can't read my writing here. Even if the defendant mistakenly thought she was provoked, the defendant is entitled to be tried as if her incorrect assumption was in fact true. So, what this means is that, you know, if you thought a home invader was coming down, was about to break through your door and come and get you, even if that was not the case, you would be entitled to have your actions evaluated as if your incorrect assumption was true. So if you acted out of this provocation where you thought, you know, you were being attacked, even if it wasn't true, you'd be entitled to have your actions evaluated as if it was the case. And so an example of this in common law is Brown from 1776, and Section 3 of the Homicide Act essentially encompasses this. However, with provocation, the defendant's response must be proportionate to the situation, and that is from a case in Mancini. So it does beg the point, was the defendant's actions in this case, firing bullets through the doorway, proportionate to the threat of a home intruder? This is quite an interesting point. I think the judge made reference to, although we have our problems in South Africa, not everyone sleeps with a gun under their pillow. And this is something that, needs to be decided on the individual merits in each case. Like, each jury in the UK would have a different opinion of what they thought was proportionate and what was not, given the situation. And it's been decided in this case, but that's just an interesting point that, where you can get some disagreement, because it's down to the interpretation in the case, which we've had already. And so there we go. And self-defense, talking about reasonable force in self-defense, I'll give you a bit of the history again. There's a case in common law, Gladstone-Williams, where the defendant makes a mistake of fact. She is entitled to have her conduct evaluated as if her assumptions were true. So same principle as in provocation. However, in Gladstone-Williams still, no benefit of entitlement is given to what the defendant perceived as reasonable force in that situation. So the evaluation of what is reasonable force is left within its normal remit, as in what force was appropriate in the circumstances. So subsequent to that, we've got Scarlett, which incorrectly applied that second point there. Scarlett was a case where there was a trespasser on someone's property, and the defendant ejected the trespasser through a use of force, and the trespasser died as a result of that. And the force that the defendant used in terms of ejecting the trespasser was excessive, and they had made a mistake or an assumption about the situation, which they sought to rely on to justify their use of force, so that they were essentially using the first part of Gladstone-Williams, where they've made a mistake of fact. They're entitled to have their evaluations based as if that was true, but they were trying to use it in relation to the amount of force they used. So they, made a mistake about this situation, used excessive force, and they were seeking to rely on that to justify their use of force. In this case, Scarlett, that was held to be all right, and I think the person was acquitted of murder. However, it is an incorrect application of Gladstone-Williams, because Gladstone-Williams relates to questions of fact rather than evaluations of reasonableness. And subsequent cases haven't followed Scarlett, so the position in Gladstone-Williams originally should stand and Scarlett should not. So, relating this to the Pistorius case here, so he's made an incorrect assumption that there is a home intruder, so we can evaluate his actions as if there was a home intruder. Fine, so he might be entitled to use some kind of force to defend himself or take some sort of action. However, I don't think, it should not be taken that his mistake about the severity of the situation should not justify the extent of force that he used. And so it would be, you could find it disproportionate amount of force used in deterring the home intruder by shooting your gun through the doorway. So yes, the upshot of this is that if force is deemed to be excessive in terms of self-defense, then the defense of self-defense fails. So, I think the final, in one of the readings, the trial judge did acknowledge that the defendant was reckless in his use of his firearms, even though he was trained. So that's why I think they found him guilty of the manslaughter. But anyway, my opinion is that given the things that I've gone over here, that I feel that there is a strong, well, it's a debatable point of law, isn't it? It's down to interpretation, that's the whole point. But anyway, if it were me in the UK and I was the trial judge, I think I've put forward some points where I would have made a very strong case for murder. So yeah, but then, you know, I haven't sat through weeks of evidence and then been given tons of time to look over it. But anyway, that's my thoughts on the Pistorius case, and hopefully that's been somewhat educational for you, or at least interesting to hear perspective from a British point of view. Thanks for watching.